Okay. So the first issue, and I'm going to share my screen here. You got to share with me, Eddie. The first issue that we're going to talk about is this one. And I want you to clear your head and just really think about the words I'm sharing with you. And the words are, something bad has happened to you. You got real sick or in a bad accident. Regardless, you're incapacitated. Alzheimer's, dementia, stroke, bad accident. You can't make decisions for yourselves. Here are the words I want you to really pay attention to. So if that happened to you, what documents or permission slips do you not only have like in a binder in your home office, but a copy of these documents are also on record with the firms that have your money, bank, brokerage firm, the firm that has your 401k or IRA. What permission slips do they have on record that are relieving them of liability for allowing your spouse, adult child, or another trusted family member or friend to have access to your retirement accounts, make a real estate or business transaction, or a medical decision now that you're incapable? Now, first things first, I say that little bit of dissertation all day, 5 days a week. And about half of the people that I share that with, their response is, Mike, I have a beneficiary in all my accounts. And I have no doubt you do. But I know you know in order to have a beneficiary, you have to die. I'm not talking about anybody being dead yet. I'm talking about your inability to make financial or medical decisions for yourself. What documents or permission slips, and I'm going to say it again, not only do you have an effect, but your financial institutions know about these documents from you while you're competent. Okay. Now, having beneficiaries on your accounts, payable on death, transfer on death, having assets titled joint tenants with rights of survivorship, none of that is a remedy to provide succession if you're incapacitated and can't make your own decisions. Now, some of you on the call are familiar with a document called a financial power of attorney. And the word durable simply means that the power of attorney is effective if you're incapacitated. I would say I've got 3 decades of work in this arena. 30 years ago, some people had powers of attorney that weren't durable. Today, if you have that document, Eddie and I are fairly confident it's durable. And all that means is that the power of attorney stays effective even if you're incapacitated. Here's something for all of you. If you ever hear anybody you know that's in a predicament, or they're frantic because they can't find the power of attorney for somebody that's dead, tell them to stop looking because it doesn't work anymore. Okay? Powers of attorney end at death. But here's what I want to make sure you know about powers of attorney. They are only as good as accepted by your financial institution. That's why you've heard me say, if you have documents, financial institutions know you have them, because an issue with financial powers of attorney is if that are older than 3 years. Hear these words. If your power of attorney document is older than 3 years, and the first time Fidelity, Vanguard, the banks that you're doing business with, if the first time they see it is from your successor, they're not going to take it. Your financial institutions want to know your wishes, and they want you to provide them with your financial power of attorney or your permission slip on who's supposed to take over and manage your accounts and make medical decisions for you when you can't. Okay? I want you to remember, a last will and testament is not a succession document while you're alive. A last will and testament, which we're going to talk about, provides instructions for how you want your assets distributed after your estate is administered through probate court. A will is a death distribution, after death distribution document. It's not a controlled document while you're alive. Okay. So if you have a financial power of attorney, I want you to know that the good as accepted language I used is not law. It's the financial institutions rules. Just like the old days when we used to pay for things with a check. Remember walking into retailers and they had a sign next to the register that said, "We don't take checks." And they didn't care if you had $1 million in it. They wanted you to provide another form of secure payment. Same thing goes with them accepting your financial power of attorney. Firms today don't want an old document. Why? Because the older the power of attorney, that increases the chance that the person that gave their, let's use mom, for example. Mom's on her own. She's the widow, or a divorcee, and she gives her oldest son her power of attorney. But then a few years later, he upsets her. She's disappointed, and she gives her daughter power of attorney now. One power of attorney doesn't cancel the other one out like wills do. So financial firms have had a scenario where the son with the old power of attorney gets to the money before the daughter with the new, and it creates havoc. So financial institutions have put their own rule of acceptance in place, saying if the first time we receive a power of attorney is from the non-account holder and the document's older than 3 years, we're not going to take it. And I want to make sure the new person that joined us hears this. Nobody's got the right to access your retirement accounts if you're incapacitated and you haven't given the custodian of that money your financial power of attorney. And just to be clear, you don't have a beneficiary till you're dead. These are problems while you're alive. So what's the remedy if somebody becomes incapacitated, including an 18-year-old child living at home with you? You have no legal right to make decisions for them because you're their parent. Okay. Once a child turns 18, if they haven't provided succession documents, guess what? There's a court process that's going to need to take place. And a court process that deems an adult incapable of managing their affairs and appoints somebody as the guardian and conservator, it's called a guardianship and conservatorship proceeding. Again, why does this court process occur? Because an adult's incapacitated and financial institutions aren't allowing anybody to touch the money because there was no legal document giving somebody else the ability to do it. Therefore, a court process needs to occur, declare somebody incompetent, appoint a decision maker, and part of the appointment process is to give them paperwork that they can give to the incapacitated person's financial institutions so that the financial institutions are relieved of liability for letting somebody else touch the money other than the account holder. Now, you've heard me say this is a court process. So we all know that means attorney involvement. And when you hear the words, we have to hire an attorney, I'm confident nobody on this call thinks the attorney's bill is going to be a few $100s. Okay. Regardless of estate size, the bill is in the thousands. And I want you to hear something. This is a court process. So if you become incapacitated today, somebody's not being appointed tomorrow. You're going to be in line waiting for your court hearing, which could be anywhere from 30 to 90 days. Okay. I want to make this real. Somebody you love dearly can't make decisions and you can't get access to the money for 30 to 90 days. And I want to remind everybody, most of us, our major money is not in the bank. It's somewhere else, like an IRA, 401k, annuity, brokerage account, or in our home, not in our bank. Okay. The bank's got a little bit of money. Anybody, your or on that jointly held bank account, no problem somebody getting access to that. But your IRA is not an or. An IRA is an individual, just like a 401k, 403b, annuity, life insurance, cash value. Those are all individual, not joints. A home, remember, if you're a married couple and it's joint tenants with rights of survivorship, they don't let just one spouse sell a home, it's both. Okay. The only account that's letting you have access for a jointly held account is the bank. Everything else, 2 signatures. Are you with me? One more item for any business owners. One of the blind spots business owners have, in addition to needing succession if they become incapacitated, is many business owners that are married, only the business owner spouse owns the business. That money's not titled joint. Hence another problem to address. Okay. So a guardianship and conservatorship proceeding occurs because an adult loses the ability to make decisions, and why they were competent, did not put any documents or permission slips in place for succession. And the financial institutions won't move till they get documentation. Therefore, this court process has to take place. Again, I want to share holding assets with rights of survivorship and having beneficiary designations on your account has nothing to do with addressing this issue. I'm going to stop right there, and I'm going to ask, does anybody have a question, either for more understanding or clarifying anything I said? And please remember, this is for you, not for me. I've been doing this 33 years. Question for anybody? I'm going to wait 5 seconds and move on to the next topic. Before I do, I want to remind you, if you've got adult children, you have no legal right to make decisions for them if they become incapacitated. They benefit from having financial and medical powers of attorney as well. Okay? What's probate? Well, probate is another court process that occurs because somebody has passed away with assets just in their name only, no rights of survivorship, no beneficiary designations. And the dollar amount that they die with in their own name is $185,000. That's the minimum. It's $184,500 is the minimum amount of money that in California, if you die with, the type of probate I'm going to talk about is certain. Hey, everybody, here's what I know about California real estate. 1/4 of your garage is $185,000. You know I'm exaggerating a little bit, okay? All right. What I want to make sure nobody's doing is self-deprivating yourself. I'm simple. I don't have a lot. Here's the amount of money that creates probate that I'm going to talk about. And if you're a homeowner in California, mortgage or not, I'm pretty confident that if you choose to use a will as your distribution vehicle, your assets exceed this minimum threshold. So I want to say that again. Having a last will and testament does not avoid probate. It is the legal document that is used by the attorney who's administering your estate through probate court. Okay, so a last will and testament doesn't avoid probate. It's the document that provides distribution instructions to the attorney your family member has hired after the administration has taken place. And what's probate administration? It's making sure the deceased person's bills and taxes are paid. Okay, mandatory 6-month time delay in California, that nothing happens other than making sure the deceased person's bills and taxes are paid. So probate is not family first. Probate is creditors and taxes first. After that 6-month time frame has expired and the bills and taxes have been handled, the last job of the attorney handling the estate is to distribute the assets according to the instructions the deceased left behind in their will. average time delay for probate in California is 1.5 years. And I've heard multiple attorneys in person and over social media. The minimum fee is 50 grand just to pass a house. What I say to clients that live in other states is probate takes a year, sometimes less, sometimes more. And the attorney's fee for settling the estate, if you add up their hourly billing and compare it to a percentage of the deceased person's assets, the fee falls somewhere between 3 to 7% of everything the deceased person died with. That's $30,000 to $70,000 per $1 million of assets to do what? To make sure somebody's bills and taxes are paid and the money's transferred to the next generation. I'm going to give you an opinion based on my experience. Why does probate take so long? Because when you're going to charge a family that much money, you better make it look like it's a hard job. Okay. Here's the other reason. Most people, if not everybody, if I was to guess, has anybody on this call settled somebody's estate? I'm going to guess most people haven't. What's the problem with that? You don't know the questions to ask the attorney if you're the person that's named as a successor. You don't know process, procedure, time frame, or fees. And if the person that you're handling the affairs for was close to you, like a spouse, you can't tell me you got clear head. You can't tell me you got a clear head at that time. You're grieving. And your children, if you have them, they don't know anything else about estate settlement than you do. And they're sad about their parent. Okay? So we name people as our successors that go in blind into our estate settlement and have no training on process and procedure. Okay. By the way, you got to know we're in the business of providing estate planning documents. And one of the things you pay for if you hire us is successor education. Successor education isn't to tell people how much money they're getting. It's to let your family members who are coming after you know what they're supposed to do to handle your affairs, not how much money they're going to get. And that's very important because successor education, especially if you have one more kid, has the understanding for everybody on what process and procedure are going to be when all the kids go through a horrible time of not having mom or dad around anymore. That's an emotional time that creates family dissension and fighting if the family isn't clear what the parents' wishes are. And let me tell you something, most families are not clear on what their wishes are after they're dead. That's why the kids fight, because mom and or dad has each told their children something a little different about what they want to have happen, and nobody's got clarity. Okay. In addition to that, you have this issue of probate. And prior to probate, if there were no documents, you got a guardianship and conservatorship proceeding to provide succession. Okay. Now, minor children. I want to make sure you know minor children can inherit money directly from a last will and testament, from beneficiary designations on your financial accounts, or as rights of survivorship. So if you have a goal to leave minor children money and you don't want it tied up in a conservatorship account, and all that means is if they're not 18, money goes through a court process, and when they turn 18, they get everything you left them in a lump sum, no questions asked. That's not such a big deal if it's $5,000 or $10,000, but if it's 6 or 7 figures, come on, everybody. What 18-year-old do you know that has the financial smarts to handle big money? None of them. Okay. By the way, joint tenants with rights of survivorship, that avoids probate, but it doesn't necessarily solve problems. Let me give you an example. I got a widow or a widower. They have 3 kids. Somebody advises them to put the oldest child in the title of their home and their financial accounts, joint with rights of survivorship, to avoid probate. And when that parent dies, it does avoid probate. But did you know that even though the will says distribute equally to the 3 kids, that the child you named as a joint tenant is under no legal obligation to do anything but keep the money because it's all theirs. And there's nothing the other two children can do. Nothing. But it's not fair. That's not what mom wanted. Law said rights of survivorship. Bank account, home goes to the one child. Now check this out. I'm a believer that most families want to follow each other's instructions. I'm a believer. And let's say my same example occurs. Mom dies, leaves the money to the oldest daughter, and her job, according to Ma, is to distribute equally between herself, her younger brother, and sister. Hear this. When she decides to follow her mom's wishes, are all of you aware that she's not following her mom's wishes? She's actually giving away her money to her brother and sister, and she's responsible for all the tax consequences in doing so. Mom's dead, left the money to the oldest. It's not Ma's money anymore. It's the oldest giving her money to the other two kids. When she's on the title of the home and the financial accounts of mom's prior to death, and mom passes away, I'm going to say it first and explain it. When mom leaves the asset to the daughter does not get a full stepped up basis on all the assets she's inheriting. She only gets a step up on mom's half. I'll give you an example. So our mom, she bought a piece of real estate, the home she's in 30 years ago, for $300,000. And today that home is worth $2 million. She puts the daughter on the title of the account. Okay. She puts the daughter on the title of the account. You know how she paid $300,000 for the home? That's called her cost basis. Her capital gains $1.7 million, right? If she sold the house, $1.7 million a gain she pays taxes on. Well, when she puts the child on the title of that real estate or that brokerage account that has stocks that have appreciated, the cost basis splits into two. And remember, I said mom bought the real estate for 300. That means her cost basis is 150, and so is the child's. When the parent dies, only the parent's 50% is stepped up to 1/2 of the value that real estate was worth when she died. Remember, I said it was worth $2 million. So the 150 goes to 1 million. Add that to the child's 150,000 basis. And now the child's got $1,150,000 basis in an asset worth $2 million. And when the child sells that asset, they're responsible for the capital gains tax on the 950 of appreciation. If mom would have died without that child on the title and the child inherited the asset, the child would have inherited the asset with a basis of $2 million. And if they sold it for $2 million, no capital gains tax to pay. Why did the parent put the child on the title of the assets in the first place? So they could avoid probate. But in avoiding probate, they've created thousands of unnecessary income tax dollars by doing it the way they did it. Okay. If you own real property outside of California, there'll be probate in every state you own real property in, and more than likely with another lawyer and law firm, because the lawyers in California can't do business in Arizona, Texas, Florida, Washington, or wherever else you got property. Okay. I want to talk about joint tenants with rights of survivorship again. Remember, it's not rights of incapacitation. So on my same example with mom and daughter, how many moms have thought about their children becoming incapacitated before them? If the child becomes incapacitated, mom don't have control over money. She gave away half. And if nobody's got a financial power of attorney, guess what? The child's got to go through that guardianship and conservatorship proceeding. And if they're married, guess what? They want 1/2 of the assets for them. And that's exactly what happens. It's not mom's asset. It's 1/2 their incapacitated child's. If the child goes through a bankruptcy, divorce, IRS lien, or any kind of litigation, mom's asset's attached because it's the kid's asset too. Okay? Avoiding probate is not the only estate planning issue that the documents I'm going to talk about address. Okay? Joint with rights of survivorship can disinherit people, for example, in a second marriage. Kids from the first marriage, both spouses. Well, they've said, we love each other. We're not going to have separation. We're a blended together family. But the law don't look at it like that. Here's what happens. My wife and business partner is named Stephanie. And let's say, for example, we're the Brady Bunch. I got the 3 sons. She's got the 3 daughters. Hear this. The first spouse who dies potentially disinherits the children from the first marriage. Because if you don't have your own distribution documents in place, meaning you die with no will, please understand your money doesn't go to the state of California. Your money is distributed down your bloodline. And in my example, with rights of survivorship, if I die first, leaving everything to my spouse, if she doesn't have documents in place and she dies, the money goes to her 3 daughters and nothing to my sons. Okay. I'm going to say one more thing, and then I'm going to ask if anybody's got a question. Here's what I need you to hear. Procrastination, or swimming in the river of denial, believing these problems aren't going to happen to you, or maybe not just yet, so you don't do anything. Procrastination lines the pockets of lawyers and law firms across this country. And that is not anti-lawyer. That is a fact. Questions on the topics I've covered so far, because I'm going to talk about solutions here shortly. If you got a question, unmute and ask it. I'm going to wait 5 more seconds and move on to the next topic. Eddie, how am I tracking? Pretty decent, buddy?
It's good, Mike. You've got about 27 minutes.
Okay. All right, no questions. Let's talk about a document called one more thing. I'm having a little brain meld right now. Has anybody ever heard of a beneficiary deed for real estate? Anybody heard of a beneficiary deed before? Yes or no? I'm trying to remember if California has a beneficiary deed. Anyways, I'm going to tell you about it. A beneficiary deed allows you to name people to get your real estate without any probate. But I don't think it's in California. They've got them in other states. But let's play pretend they do. Check this out, everybody. Let's say you put 3 kids on as a beneficiary of your real estate and you die. Are you aware of the problems you've left behind? They've all got to agree to sell. What if one of the children was in a condition where it didn't make sense for them to inherit the property? They were going through bankruptcy, divorce, IRS liens, some kind of litigation, or they were incapacitated, or they were a special needs kid. That beneficiary deed isn't solving problems, it's creating more. Just like rights of survivorship, and by the way, ladies and gentlemen, your other beneficiary designations you have. Remember, your beneficiary designation on your life insurance and your 401k and your IRA, it does not allow for delayed distribution if those beneficiaries are in a situation where it doesn't make sense for them to inherit. Okay. Before I start talking about a trust, did I create any more questions from what I just said there? Okay. So, revocable living trust. Hopefully, all of you know the word revocable or revocable, tomato, tomato, potato, potato. It means you could change your mind. So this revocable living means when you sign it, it becomes effective right now, not after death. That's testamentary. Okay. Revocable living trust. What is it? It's very, very simple. A revocable living trust is simply a contract of your instructions on how you want your finances handled and by who. When you're competent, that's you. When you decide to set up a trust, nobody's interfering with your decisions. You're the trustee. You buy, you sell, you deposit, you withdraw, you spend all your money, just like you could now. But this trust is a contract of instructions that allow you to appoint a successor if and when you become incapacitated. And could you have more than one successor? For example, you got 3 kids. Could all 3 serve? They could, but they got to agree. Okay. But there's no limit on the amount of trustees you can have. Okay. The point is, in your contract, that's what a revocable trust is. You name who's going to make your financial decisions for you when you can't make them for yourself. That means managing your money, paying your bills and taxes, and using your dollars for your care while you're incompetent. When you're dead, you've provided instructions for that same successor. And what are they going to do? Well, they're going to pay your final bills. They're going to pay your final taxes. And then lastly, they are going to follow the distribution wishes of what you want done with the assets that are left over after you're done using them. Okay? To who, in what amount, and under what time frame? Because with a revocable trust, you can delay distribution. Why would you delay distribution? Because you got minor kids and you want to wait for them to get 18, 21, 25. Hear these words: before the minor gets control. Don't misunderstand that they're not benefiting from day one. You've named an adult to manage the money on their behalf until they can make decisions. So you might have a need for delayed distribution for minors, for spendthrift heirs, for children that are special needs and can never manage money, for second marriage situations, to leave a life estate to a spouse who maybe didn't bring as much money to the marriage, but leaving the surviving spouse who had less money. A life estate doesn't commingle the dollars of that first parent's assets. And when both spouses are dead, the life estate ends and the money goes back to the kids, to the parent who brought all the money to the marriage. Okay. You could have children that are incarcerated, drug use. That doesn't mean you don't love them. It just means you don't want to give them money for them to keep hurting themselves. So your trust allows for delayed distribution. Okay. So a revocable trust is a contract of your instructions on how you want your finances handled while competent, same way you're handling things now. If you become incompetent, who's the person or people you trust to handle it? And after you're gone, who's the person or people that are going to pay your final bills and taxes and then follow your distribution wishes, which could be as simple as, I have 3 kids. After my affairs are handled, divide the estate into thirds and my plan's over. Are you all with me? What the revocable trust does is what people think a last will and testament does. That's a fact. But they're 2 different documents. A revocable trust is a contract that doesn't die or become incompetent. And a last will and testament is a distribution document after somebody's dead and their affairs have been administered through court. Okay. What a revocable trust also is, in addition to the contract, it's another way to take title to assets and property. So Eddie and Katia, they don't take title to their assets in joint with rights of survivorship anymore. They take title to their assets in the name of the Soto Family Trust, Eddie and Katia Soto trustees. Their real estate is in the name of their trust. All of their financial accounts, but their IRA and 401k are all in their trust. Their golf cart, their boat trailer, their automobiles, their boat, farm equipment, anything that's got a title is in the name of the trust. There's no negative to it. No negative happens for moving assets from your name into the name of your trust. And hear this, you don't even file new tax returns. Why? Because the tax ID number of your revocable trust is your Social Security number. So if you decide to put your trust in place this year, when you file taxes for 2024, it'll be the exact same forms you used for filing 2023. Okay. So the trust is a contract of your instructions on how you want affairs handled. It's also another way to take title to your assets and property. All assets but your 401 and IRA go into the trust. You don't put 401 and IRA in. Why? Because you as the individual are getting the tax deferral So the government says if you pull money out or change ownership, you're going to pay taxes. That's why we don't do it. However, what we do is part of an estate plan includes not only a revocable trust, but a financial and medical power of attorney. And what we do for our clients that have the IRA 401k money is we have you give them a copy of your financial power of attorney right now while you're competent. So they are put on notice when you can't handle your affairs. Your oldest child, I'm making that up, of course, your oldest child is your successor, and they already know about it. All your successor needs to do to take over is prove you can't handle your affairs. That's either doctor's letters saying you're incompetent or a death certificate saying you're dead. They got to provide identification that they are who they are. And then they got the original documents that they got out of the binder in your house that show they're in control. And that's how succession takes place. Bills and taxes still have to be paid. That's why this planning process is not too good to be true, because nobody in California and nobody in the federal government, nobody cares if you have a guardianship and conservatorship proceeding. Nobody cares if your estate settled through probate or it isn't. The state of California cares about its tax revenue and protecting its business owner citizens to collect their receivables. So that just means bills and taxes. Okay? Nobody cares. Court supervised, processed or not. They just care that it's done. And no matter how you decide to handle your affairs, your bills and taxes got to be paid. Now, you've heard me say there's a need to transfer assets into a trust. If you know anybody that has a revocable living trust, one of the holes they have is they don't have any assets in it. They've got the document with nothing in it. Okay. In order for the trust to avoid the court processes, the assets need to be in the name of the trust. They can't be in your name. Okay. I'm going to answer a question all of you have before I ask you if you have questions. Many people will say, now, Maloney, does that mean every time I buy a house, sell a house, open and close financial accounts, do I got to call your firm and pay you more money to do it? No. The only time you're going to have additional fees with your document, hear this, is if you change who your successors are after you're gone. That's a contract change. I don't want my son Bill to be my successor. I want my daughter Stephanie. By the way, when you change your successor, you're changing them in all your documents. Okay. The other area that creates a fee is if you change your distribution wishes. Okay. Let me role play with you so you get clarity. So the Sotos are going to put their home up for sale, hypothetically. Stephanie and I want to buy the home. We negotiate the price. We wire the money to the Sotos checking account. You all know they have a trust. So are you with me? The title to their checking account is the Soto Family Trust, Eddie and Katia Soto trustees. That's how the title of the contract reads. That's the statement. When they look at the title of the statement, comes in the mail or online, the statement's in the name of the Soto Family Trust. So the money's there. We are sitting at title company. The title company asks, hey, Mike and Steph, how do you want to take title to your new home? And we say, the Maloney Family Trust. Michael and Stephanie Maloney trustees. The Sotos find a new home. They negotiate the price. They wire the money out of their checking account to the seller. They're sitting with the title company, and title says, Eddie, Katia, how do you want to take title to your new home? And they say, Soto Family Trust, Eddie and Katia Soto trustee. That transaction is not a change to your trust. It's an addition. It's an asset, part of your estate. The key is to take title in your trust. That's the key. All right. Before I open up for questions, why does the use of a revocable trust avoid the court processes? It's this simple. When you establish a trust and you retitle your assets into the name of it, which if you hire us, we're going to help you do that. Okay. But if the assets are in the name of the trust and you become incapacitated or die, what assets are in your name? Nothing. Your contract that you controlled while you could, provided succession for when you couldn't. And remember, all of the firms that have your money know about your instructions. And the too good to be true, the reason this isn't, because I already told you, bills and taxes have to be paid. Who has questions for me so far? Please, the right word might not be intimidated. Don't be intimidated. This is maybe a lot of your first times ever hearing this. Feel free to say anything. Feel free to say, but I thought it worked like this. Anything you need to say, this is the time to do it. Okay. I promise you, in my 3 decades, I've heard all the questions. However, I know this, when I don't have any questions, it means I'm making sense. If I'm not making sense, I got to say something very respectfully. If you don't put planning documents in place like this and you know you have these problems, if you choose not to do the documents, your family's hiring an attorney and going through court processes that I've described to handle your affairs. It's not a maybe, it's an is. Okay. No questions so far? Okay, I'm going to button it up here. I got 5 more minutes. An estate plan includes multiple documents in addition to a trust. No matter who you hire, and Eddie and I hope you hire me, in addition to the trust, you're going to have financial and medical powers of attorney prepared. A document called nomination of guardian that goes with your healthcare document. Okay. Care facilities like to know the guardian of an incapacitated person. That's why we prepare it. Married couples, you get a community property agreement. Why? To signify that you want to use the state of California's community property law for the full stepped up basis at the death of a first spouse. By the way, if you hold assets joint with rights of survivorship, that's not community property law. Community property with rights of survivorship is getting the full stepped up in basis. Joint tenants with rights of survivorship only has a 50% up. So married couples, if you don't do the trust, consider switching title on your jointly held assets to community property with rights of survivorship. Okay. It doesn't avoid guardianship and conservatorship, and it doesn't avoid probate forever, but at least you get that full step up. We transfer your personal property into your trust with a document called an assignment. It assigns your personal property, jewelry, firearms, artwork, anything that doesn't have a title. We prepare a summary of your trust document called a certificate of trust, and that's normally given to your financial institutions. Why? So they know the names of your successors. That's why. Okay. We prepare new deeds to transfer your real estate into your trust. We transfer business interest into your trust. For the fee I'm going to quote you, not only do we do all that work, but after your plan is in force and funded, we recommend we get in front of your successors in a meeting like this so they understand what the heck's supposed to be done when the bad times come. And lastly, we provide our clients with an online vault that they can store these documents and they can be accessed worldwide, not only by our clients, but by their successors when the time comes. Our planning fee is not based on any of our clients' ability to pay. Our planning fee is based on work. And what is work with estate planning? Comes in 2 areas. How many deeds and businesses do we have to transfer? In our fee, our planning fee includes 1 transfer. Each additional deed or business transfer is going to be another $250, and you'll know that in just a second. Okay. Where else the fee can increase is depending on the complication of your distribution wishes. Equal to the kids is very common and not hard, but everybody's not equal to the children. They have all of those other distribution wishes that I've covered. So the more ifs, ands, and buts, and howevers, and therefores, that just takes a little more time to draft. Therefore, is going to cost a little bit more money. So our base planning fee for single people is $2,000. For married couples, it's $2,500. And everybody needs to understand this. The cost for handling your affairs when you have no documents, and that is an estate plan. Because when you have you don't have your own documents in place, State of California's court processes are the documents. And when you have to get an attorney involved, I promise you, the fee your family's paying out of your assets will amount to 10 to 20 times more than anything you're going to pay me and my team. So that's another way of saying, those of you that don't have documents, your estate settlement fee is 10 to 20 times more anything you'll pay me to get it done right in the first place. Okay. Questions from anybody? Questions? No questions? Okay. Teresa, do you have a question or are you all right?
I do not have a question. I have a really bad cough. That's why I haven't been able to talk. I want to thank you, Mike. You're very clear. You're very knowledgeable. And I just want to thank you. That's about it. Before I start coughing, I'm going to mute myself again.
Mute yourself, and I appreciate your feedback and compliment. Thank you very much.
Thank you, Mike. And thank you, Eddie.
You're right. Next steps, if and when. You're all invited to have a complimentary consultation individually. If you decide to have it, that is not your commitment to move forward. You're having a consultation because you have questions you don't want to ask in front of everybody else. So just know if you want to have a consultation, Mr. Eddie's going to reach out to you, make sure all of you like the information. And then if you want to talk again, Eddie's going to schedule with you. Okay. No obligation. If you're ready to go and you want to know what the next steps are, let me tell you, Eddie's got a data form to send you. And what data do we need for your estate plan? Well, let me tell you what we don't need. We don't need anybody's social security numbers, and we don't need any financial account numbers. Isn't that fantastic? We need contact information, name, address, phone, email, date of birth of you and the children that don't live with you. And if your children aren't your successors, the contact information for that non-child who's also in the document, name, address, cell phone, date of birth, email. We need to know who your successor is going to be. We need to know how your assets are going to be distributed. And there's room on the form to tell us all this. We need the legal description to your real estate. If you have a mortgage, that's in your mortgage paperwork, lot 41 in the subdivision of. If you own if you own your home, then you got a deed showing you owned your home when you paid off the mortgage. If you're a business owner, we need the operating agreement, because after you put your trust in place, that's when we put the assets in. And when we're going to put the financial accounts and all that good stuff is after your documents are signed and executed. Okay. And by the way, how long does it take to do these documents? 3 business weeks. And that's after we get all the information from you. Okay. Not part of the information, all the information. Then the 3 weeks start. And when do you pay us? You pay us when you sign your documents on that day. Okay. So we've got a virtual handshake agreement that when you hire us, we're going to do the documents. And when you get them, you're going to pay us. Okay. Who has a question for me? Okay. Mr. Eddie, I thank you for having me on today. If any of you on the call want somebody else you care about to hear this information, you know exactly what they're going to hear. And I'm confident nobody felt pressure to do a gosh darn thing. Okay. And I want you to know that if you refer us, all that's going to happen to anybody you refer us to is they're going to hear this education. And then if I could use a phrase that we're all familiar with, then the ball's in your court telling us when and if you want to move forward with us. Okay? If there aren't any questions, I want to thank all of you for your time today. I very much appreciate it. And Eddie, anything to say and close us out?
Oh, Mike, I think that was an excellent delivery. I think that that certainly probably created more questions in the minds of people that are here in attendance. We're going to be sharing this recording with you as well, so we'll look forward to that in an email. That way you can reference it if you'd like to, or share it with somebody that you'd like to share it with as well. So Katia wasn't able to be with us tonight, but she wanted to make sure that whoever was here present that works with her with their health and Medicare. That sorry she missed you, but she's glad you participated in the program tonight.
By
So,
the way, for those of you that use the SOTOs for your Medicare, if you become incapacitated, your family needs the financial power of attorney to address the insurance premium. Medicare is not a medical issue when it's dealing with the money. Did you hear me? If you're incapacitated and you don't have a financial power of attorney, your agent cannot effectively deal with your successor because you haven't provided them with the permission slip to do it. Okay. In closing, do not self-deprivate yourself that you don't have the issues I reviewed. People that don't have the issues I reviewed are renters with a bank account that barely has any money in it. You don't have all the issues I talked about, but even that person needs a financial and medical power of attorney. Do not self-deprivate yourself. If you have children that you want to hear this education, schedule the call. Okay? Remember this, and I'm saying it on purpose. Swimming in the river of denial forces us to procrastinate or allows us to procrastinate, making us believe we got plenty of time. And I've yet to meet anybody that can tell me the day and time they're leaving this world. And just because you're older, don't mean younger people aren't going to have a problem before you do. 1 out of 4 Americans doesn't live past the age of 65. Eddie Van Halen and Bob Saget, Tom Petty, all lived to 65. James Spader, the actor, died yesterday at 64. Michael Jackson and Prince made it to 55. Kobe Bryant and his daughter, 41 and 15. Don't make the mistake in letting procrastination get in the way of making sure that when you can't control your affairs, somebody you want is doing it without outsiders' intervention. That's what estate planning is about. Eddie and the rest of you, thank you very much for your time, and I appreciate you all listening to me. Have a great day.
Mike, you too. Thank you.
You're welcome.